Thank you. Good evening, everybody. I'd like first to thank Nicolas for having invited me here. I'm really happy to be here today to converse with you about copyright, and especially about public domain, who might be the other side of copyright. I've been working on the public domain for the last 3 to 4 years, and so I would like to share with you some of the puzzles that I have encountered in that research. And public domain seems to be a very contemporary research topic or concern. In IP, there is a strong public domain movement, both in scholarship but also in activism about copyright, or maybe more against copyright, that takes public domain as a sort of agenda to fight for. But actually, the public domain goes a long way back. As in the history of copyright, because already in 1878, Victor Hugo, the famous French writer, declared that we hope to confirm literary property, but simultaneously we hope to establish the public domain. Let's go even further, let's broaden it. And it was really interesting because at the time he was delivering the keynote speech for a big international conference about copyright that was the beginning of the discussions about what would become the Berne Convention. So it was really interesting that this writer, who fought a lot for establishing an international copyright, said that at the same time public domain had a role to play in copyright. And if you jump 130 years later, you have James Boyle, who is a very well-known proponent of the public domain, who says that we have to invent the public domain before we can save it. And actually, my research relies on those two quotations, because in those two quotations, I think there are key elements to take if we want to set up an agenda for the public domain. The first one is to say that public domain is an integral part of copyright. It's not something that is outside of copyright. It's not something that starts to exist when copyright is over. It is something that is within copyright, as Victor Hugo said at the time. And this is something that should not be neglected, but should be preserved and should be broadened. And James Boyle is saying that before we try to save public domain, to preserve it, to fight for it, maybe we should construct it in a way. We should maybe make it happen in a way. And I would like to share with you some thoughts about those two objectives in my research. Public domain is commonly understood as works whose copyright is expired. But actually, public domain is bigger than that, because it encompasses all the things that are not protected by copyright, not protected anymore by copyright, or things that will never be protected by copyright, because they are not eligible for the protection. I will come to that a bit later. I will go into more details to what is the public domain. But actually, it means that the way we conceive public domain in copyright means that we have only a negative perception of public domain. Public domain is generally defined as what is not protected by copyright. And this negative definition, if you want, is something like that. It's to say that the picture is really bright, so with the light you won't see it, but it's an archipelago. And actually, it's, if you think that the key principle in intellectual property is the freedom of copy, the freedom of copy would be the sea, and then you have some islands, IP islands, and here some copyright islands, things that are protected. And the sea would be the public domain, the things that are not protected anyway. And regularly, some seas would return to the island. And actually, the notion that we have about the public domain in copyright is inherently a notion of a reverse copyright, a negative definition. And it's the same with the sea, you know. Any cartographer in the past century made the mapping by looking at the Earth, at the limits of the Earth. And the sea, the limits of the sea were just drawn based on what he knew about the boundaries of some islands. And it's the same in copyright, actually. We don't define the public domain by saying it is that and that. We say copyright is that, and by consequences, public domain is what is left. And so this is something that this reverse definition of copyright for the public domain actually is something that explains many things in what is happening today in the scholarship around public domain. First, I think what you can read about public domain, for a large part, participates in a movement that is also a movement against copyright. There are a lot of reasons today to be maybe against copyright or against copyright as it turned out to be, but actually a lot of things that you can read about public domain is more about fighting copyright than about fighting for the public domain. And that gives some biases to the research, I think. And the other thing also is that a lot of scholarship about public domain is about warning against the increasing scope of copyright and the fact that public domain is threatened by this increasing copyright, and that we should defend it against an increasing enclosure. And you have a lot of things that have been written about public domain, mainly in the 19th, maybe at the beginning of the 2000 years, where they said public domain is in jeopardy, is in danger of a greater enclosure. But actually, it doesn't say much about the public domain itself. It doesn't say what could be done with the public domain. And some of the problem here is that the reverse definition that we have of the public domain weakens it also. The public domain is really weak in copyright because there is no guarantee that things that are in the public domain will be freely available to all, that it will be freely there to be used. And I will give you some examples later on of that. And what I would like also to point out is that the public domain is really relative. Public domain is only free because it's not protected by copyright, but it can be protected by other things. It can be excluded by other rights, by other legal entitlements. And so it means that in itself, public domain is not really immune from any encroachments or any limitations. So I think that the key issue today of the public domain lies in the very definition that we have about the public domain. And we need to change this definition and to give some positive value of the public domain, and maybe thinking about a legal regime that could embed some key values of public domain and make it stronger within copyright regime. This is what I would like to explain to you in that lecture. But first, why does it matter? Why public domain matters so much today? And why is it something that it is worth to fight for? First, because the public domain has, or at least people have discovered recently, that public domain is a great value in many regards, because it contributes to creation and knowledge as copyright does. And this is something new in the conceptions of the intellectual property, because usually copyright was the thing that has value, and public domain was the useless trash. You know, think about the expression "a work has fallen into the public domain." It's an expression that really conveys the perception that once it falls in the public domain, it is just useless trash. It's something that doesn't have any value. And this is something that is changing. This is a new discourse on public domain that thinks that public domain matters and has value. And I will give you some examples. Public domain has always been a material for new creation. Okay? This is one example. Disney, for instance, has always done a lot of its movies by taking stories that were in the public domain. Great fairy tales of the Middle Ages and later on were in the public domain, and Disney just took some new creations out of it. But also not only works that have fallen in the public domain, but also the thing that a plot, a mere idea is in the public domain. And it is in the public domain, so other creators can build upon it. If you take, for instance, Romeo and Juliet from Shakespeare, it is in the public domain now, so it means that, of course, you can do a lot of adaptations of it, and it brings regularly new plays, new films, new things that are based on Romeo and Juliet. But also you can take the plot, the idea, the story of those two teenagers falling in love, coming from adverse enemies' families, and you can make other things. This is a picture of West Side Story that is actually the same story as Romeo and Juliet. So this shows that public domain is there to create further things. Public domain has also become very important as it has led to some project of digitization of material that was in the public domain. You might know the Project Gutenberg that for many decades now have been putting books in the public domain in a digital form, freely available online. You have also the Europeana, that is, I think, one of the biggest cultural projects of the European Commission that tries to put all the cultural heritage of European Union online for everybody to see, to browse, to look at. And this is built on public domain material. Public domain has also showed that it provides some access to works at a low cost. I will give you two examples. The first one is Freud. Freud has fallen in the public domain, has entered in the public domain 2 years ago, in Europe at least, and with other people in Europe, we've made a short survey on the new editions of his books that were released at the time that his work was in the public domain. And for only 1 year, in some countries, there were 10 to 15 new editions of his books. By comparison, the years before that, there were only 2 or 3 editions each year of his books. So it means that suddenly the work is in the public domain, and there is a regained interest in publishing his book, in spreading the knowledge, the culture in a society. Another example is about this movie that you might have seen maybe several times around Christmas times, and It's a Wonderful Life. It's a film that was released in 1946, I think, and in the US, and it was not a great success at all. It was really a flop, a commercial failure. And at the time, copyright in the US was valid for 28 years after registration, and you had to renew it for another term of 28 years. But usually, major film studios didn't renew the copyright because there was a time where there was no DVD, so there was not a new exploitation period. So once it was released in theaters, it wasn't very successful. You had no commercial interest in renewing the copyright. And that copyright was not renewed in that film. So it was in the public domain in the beginning of the 70s. And at the time, public broadcasting in the US just picked up the movie because it was for free. You could broadcast it for free. And they started broadcasting it, and then it became a huge success. And people just loved that movie. And now, each Christmas, I think that usually on BBC, you have this movie. Okay, in Europe it's not in the public domain for many reasons, but in the US it has become a great success because it was shown so much. And also, public domain is not only about cultural value, it has a market value and commercial value. Look at Google Book Search. Google Book Search started its successful business model by taking public domain books and making them online. But you have other people out there who use public domain works as a commercial factor. For instance, if you look at the Kindle that is sold by Amazon, one of their marketing argument is that you will have millions of out of copyright public domain books through your Kindle. So it's something that gives some material for those companies to provide you for free against advertisement, or maybe not for free in the next future. We will see. And then in the current debate about the public domain, there is a lot of arguments about the value of public domain works for developing countries. I won't elaborate on that because I think it's a bit complex. It's not as always as it appears to be, but it's true that developing countries are asking for public domain material to access to knowledge for education purposes and things like that. So all these value, all these examples show that that public domain works can begin a new life, and they have a value, whether social, cultural, market-based, and it also shows that the value of that public domain begs the questions of whether we should maybe preserve that value or enhance it or promote it, and to make more public domain works having this new life on the market in the society. And to show you, to develop this argument, I would like to go more into the details of the composition of the public domain, and maybe come back to the definition, to the negative definition of the public domain, because this negative definition doesn't help much in capturing this value or promoting this value. For two reasons. One reason is that public domain is really difficult to identify because it is different from one country to another. Because it's based on copyright, and you know that copyright is based on territory. It has a territorial scope, so what is protected by copyright in one country is not the same than in other country. So by definition, it means that what is not protected by copyright, what is in the public domain, will vary from a country to another. And I will give you a lot of examples that shows that it's very complex to know whether one work is in the public domain or not in one territory or another. And the other reason is that because the public domain is only what is not protected by copyright, actually is very unstable, because there are a lot of reasons why, even though it might not be protected by copyright, it will not be easy to say it will never be protected by copyright, or it will never be protected by anything. I will also give you a lot of examples by looking closer to the composition of the public domain. So I told you at the beginning that public domain was not only was not only the works whose copyright has expired, but could be anything that is not protected by copyright. So if we want to be more rational, we could, or actually this is how I do it, I just divide the public domain in 5 big parts. The first part is what I call the ontological public domain. It's IDs, it's based on IDs. You know this dichotomy between IDs and expression in copyright. Expression is what is protected. IDs are never protected by copyright. This is the core of public domain. IDs will never be protected by copyright. It's the easiest part, maybe, in the public domain. The other part is what I call the subject matter public domain. It is composed of anything that is uneligible to copyright protection because it lacks originality, and for other reasons also. I will come to that in a moment. Then you have the expiration of the copyright duration, the temporal public domain. You might have, but it's a very, very limited part of copyright, some exclusions that are provided by the law. It can cover official acts in some countries, not in the UK, but in many countries in the world. This is what I call the policy public domain. And then you have a new creature in public domain. I think it's what I call the voluntary public domain. It's based on all those works whose authors has decided to relinquish their copyright. They don't want their copyright in their work, and they just say, I put that in the public domain. Okay, let's go into each part. ontological public domain. So it's composed of IDs, methods, information, raw data, news of the day, the Berne Convention says. It is what I told you, the core element of the public domain. It is something that seems untouched upon. It cannot be encroached by increasing copyright. But at the same time, we know that it's also a bit fragile. We have the sui generis rights in database that more and more appropriates data, information. It's true that in the last year, the European Court of Justice has maybe been reassuring on some parts of the sui generis rights. Also, a reassuring element is maybe you might have read the conclusions of the Advocate General in the SAS Institute case concerning software, where this principle of exclusion of IDs from copyright has been really confirmed. But we'll have to see what the court will say. The subject matter, public domain, mainly covers non-original works, those works that are not eligible to of copyright because they lack of originality. But actually, it might not be very easy to define what is this part of public domain, because the level of originality in many countries is very low. So a lot of things are just eligible to copyright. And even though this definition has been harmonized at the level of the European Union, it seems that the criteria that are used by the European Court of Justice are really open to welcome a lot of works in the scope of copyright. There are other exclusions from copyright scope, depending on the country. Most of them are really not so important anymore, like foreign works. A lot of countries says that we don't protect foreign works, except even international treaty forces us to do so. And of course, a lot of countries are part of the Berne Convention now, so there are less and less foreign works that are not protected. Formalities in some countries used to be important, are not anymore. I come to the public domain that is composed by the expiration, the lapsing of time. This is a very big part of the public domain. You know the general rule in the European Union: the copyright lasts for 70 years after the death of the author, and there are specific rules for some works. Actually, this part of the public domain is important because it seems to be that all works will one day or another fall into that public domain. But actually, one can say that it might be more another day than one day, because there have been a lot of extension of copyright duration in many countries. In Europe, we have come from 50 years after the death of the author to 70 years after the death of the author. In the United States, there has been a very controversial extension of copyright in 1998 that has been challenged before the US Supreme Court. And what is interesting is that the US Supreme Court didn't pay any attention, or so few, to the public domain argument. They said, okay, yes, we can extend copyright. What's the problem? And to the people that said, there is a problem for the public domain, Supreme Court said, but no, the public domain will still be the public domain. It will just happen later on, but there will still be a public domain. And so it shows that the main focus of copyright is about protection. It's not about keeping a public domain alive, as Victor Hugo used to say. You might know also of this stupid piece of legislation, the directive, the last directive in the European Union on duration of neighboring rights. It doesn't concern strictly copyright, but it gives some rights in sound recordings, and it extends those rights in time. And here also, there were no concern about public domain, no economic studies about the impact it might have on the public domain. So it means that public domain seems to be a useless trash for lawmakers. Other factors make that temporal public domain very undefined and very unstable. And then it becomes complicated. First, I said to you that public domain was based on territory because copyright was based on territory. So it means that duration of copyright, as the Berne Convention reminds, is governed by the legislation of the country where protection is claimed. There is a small exception for works of folklore. So it means that actually, to know whether a work is in the public domain or not, it will depend on the law of the country where the protection is sought. You have here a map of copyright duration. The biggest champion of duration of copyright is Mexico, with 100 years after the death of the author. Otherwise, you have Europe with 70 years that has been followed by a lot of countries who know a rule of 70 years after the death of the author. You still have some countries who know the 50 years after the death of the author, the Berne Convention minimal rule, and then you have very strange cases of different duration, different things. Let me give you an example of how complicated it can be. Here are two authors that you might know, James Joyce and Virginia Woolf. The thing they have in common, they might have something in common, but one of the things they have in common is that they are both dead in 1941. So if we look in Europe, let's take some things that they have written. If you look in Europe, the rule is 70 years after the death of the author. So it means that from the 1st of January this year, the works of these authors are in the public domain. You can freely use it, reproduce it, communicate to the public, making it available as soon as it is in Europe. Because, for instance, if you look in the United States, the rules are different. The rules on duration of US copyright are very, very complicated. But let's say that all works published before 1923 are in the public domain. So, Ulysses has been published in the US in a series from 1918 to 1920. It is in the public domain. The Voyage Out of by Virginia Woolf has been published in 1920. Before 1923, it is in the public domain. Mrs. Dalloway has been published in the US after 1925. That means that it's not in the public domain. Actually, it's still copyrighted. And the rule is, because of this copyright extension that the US has enacted in 1998, it won't fall in the public domain until 2019. And so it means it's really strange because you have, for the same author, some books are in the public domain and others are not. So in the US, you need to know the date of publication of the work and many other elements. And in Europe, you need to know the date of death of the author. But it's really complicated. If you want to set up a website with works that you want to make available, for instance, the Project Gutenberg, you had Ulysses of James Joyce that was available on the Project Gutenberg website for many years now. And you could get it. It was based in the US law. But it said also, there was a warning saying this book is in the public domain in the US, but maybe not in your jurisdiction. So just check it before you use it in your jurisdiction. But it makes it very complicated for people who want to extract value out of those public domain work. Okay, so this is complicated, but actually it's not that complicated if you look to other rules. There is another rule in the Berne Convention that we call the rule of shorter term. It means, it's the second part of the Article 7.8 of the Berne Convention. It says that unless the legislation of that country otherwise provides, the term shall not exceed the term fixed in the country of origin of the work. So it means that once you want to define the duration of a work, you need to know the rule of your country, but you need to know the rule of duration of the country of origin of that work. And you compare. And you take the shorter one. No, you take actually, no, it's not the shorter one. You take normally you use the term of protection in your country, but if the duration is shorter in the country of origin, you will need to take that into account. I will give you one example. Another writer, Indian writer that is a Nobel Prize author, Rabindranath Tagore, is also dead in 1941. Normally, one could say, in the UK, it is now in the public domain from the 1st of January of this year. But in India, the copyright lasts for 60 years after the death of the author. So it means that in the UK you apply the rule of shorter term. It has been in the public domain since 2002 because it's 60 years. Even in the UK, it is not governed by the same rules of duration than European works. But in the US, they don't know the rule of shorter term. Berne Convention doesn't impose that rule. And so it means that in the US, it is published under the same rules than the other US works. So it makes it very, very complicated. There is another thing that is called copyright restoration. Copyright restoration is a rule that in some cases there was no copyright anymore, the work was in the public domain, and suddenly it is restored. Suddenly you say, oh no, we take it out of the public domain and we put a copyright on it again. And there are several instances where it can happen. The first is the Article 18.1 of the Berne Convention that says that it applies to all works which at the moment of its coming into force have not yet fallen into the public domain in the country of origin through the expiry of the term of protection. That rule actually had the objective, and still has the objective, that countries that are new adherents to the Berne Convention will restore copyright protections on works who have fallen into the public domain, who have not been protected under the law of that country. The easiest example is the US. When the US entered the Berne Convention in 1989, US knew a system of formalities. Were protected in the US if they were registered at the Copyright Office. And so it meant that a lot of foreign works were not protected under US copyright law. But since the US entered the Berne Convention, formalities were now prohibited. So by entering in the Berne Convention, it had an obligation to protect again those foreign works, European works for instance, that suddenly had to have this level of protection. There has been two very interesting cases in the recent years around this rule. What time? Okay, I still have some time. The first one was in France. It concerned His Girl Friday. Like the other films that I talked to you about, this film was in the public domain in the US. Copyright was not renewed on that film. I think it was released in 1941 or something like that. And so it was in the public domain from 1970 or 69. I don't know, so 70, yes, 28 years. And copyright was not renewed, so it was in the public domain in the US. So a French DVD producer think, oh, it's in the public domain in the US, so it means that I can release some DVD with that movie with not asking for any permission, because I have to apply the rule, the comparison of terms. It's not protected anymore in the US. I don't have to apply the rule of the French duration of 70 years after the death of the author. And in that case, the author, Howard Hawks, has been dead in the 70s, end of 77, I think. But actually, the French Supreme Court said, no, it doesn't apply that way. You have this rule of copyright restoration, so it means that you cannot prohibit, because you cannot, it's a very complicated decision, but they mixed some arguments. One argument was copyright is restored because when the US entered the Berne Convention, suddenly it gains all the protection that the other members of the Berne Convention know. And for instance, it cannot be protected less than 50 years after the death of the author, so it's still protected. So you have that work that is not protected in the US even today, but is protected, for instance, in the European Union. So it's a really strange case where something is not protected for many years in the US, but is still protected in other countries. Another case is the Garland versus Alder case, which just had in the mid of January the decision by the Supreme Court. That is a very interesting decision. In that case, what happened was the following. When the US entered the Berne Convention, because they needed to restore copyright in all those foreign works that were not protected under US law because normally they never complied with formalities of registration and so on, the US enacted a law restoring copyright on those works, saying all those works who lack any protection in the US because they have not complied with formalities are suddenly restored copyright, and they will be copyrighted at that time. And actually, Mr. Gordon had a website where he made available a lot of music sheets from composers of music of the 20th centuries, most of them European composers like Shostakovich, Tchaikovsky. People who are not in the public domain in Europe, but who were in the public domain in the US because they had not complied with the formalities for registering their works, their music in the US. And this guy suddenly saw this new law coming and said, but suddenly all the things that I do on my website will be illegal because those works suddenly will be copyrighted again. And so he challenged the constitutionality of that law. And it's lasted for many years. It started in 2004. And what is interesting is that we have a decision before the 10th Circuit of Colorado that said an interesting principle. It says, what is in the public domain should remain there. We cannot take something out of the public domain and make it copyrighted again. So that was a sort of very strong principle to say. But actually, the US Supreme Court, so 3 weeks ago, said neither the Copyright and Patent Clause nor the First Amendment makes the public domain in any and all cases a territory that works may never exist. So the Supreme Court said no. Public domain is, by definition, unstable. Things may fall in the public domain, but nothing guarantees they will stay in the public domain. There is no principle that makes the public domain completely immunized against restoration of copyright. And it's a very interesting case for that because it shows that in the moment, in our conceptions of copyright, public domain is just useless trash or a fallow land where you can just go pick and grab things and make it copyrighted again. We have other cases of copyright restoration in Europe. I won't go into the details. There is one that is really interesting. It's about songs by Bob Dylan. It's not a copyright case. It's a case of neighboring rights. It was a right in sound recordings by Bob Dylan. And what was interesting in that case is that the European Court of Justice just restored protection in those phonograms in Germany, where those phonograms, for technicalities of the law in application in Germany, have never been protected. So suddenly you have sound recordings that never got any protection in one country, and suddenly you have a neighboring right vested upon them. This is what a friend of mine, Valérie Lorbenabou, called the zombies of copyright, the walking dead of copyright that suddenly come back from their grave. I will just say a few words about the two last parts of public domain, but it will be very quick because it's simpler, I think. The first one is what is excluded from copyright, specifically by law. It's not much. It's not like in patent law where we have a lot of exclusion. In copyright, it might be in most countries official acts, but not here because of the copyright crown. But even official acts are not really immune from any reappropriation or commodification. For instance, there is a decision of Court of Justice that doesn't seem to be concerned by the fact that you can have a sui generis right in a database comprising official text and case law. There was no problem at all, even though the thing that has been taken by the competitor might be deemed as being non-protected by copyright. The last part of public domain is more interesting, I think. Part of this anti-copyright movement, a lot of creators themselves, a lot of authors themselves said, we don't want the copyright. We want to give our copyright away. We want to put our works in the public domain. You have the Creative Commons licenses, but you keep copyright. And then you have a more radical version of Creative Commons licenses that says, we don't want any copyright. We just abandon the copyright. But actually, this is also a tricky part of the public domain because there is a lot of questions about the validity of such act of relinquishment. Is it valid to just say, I don't want my copyright anymore? What about moral rights? Do they stand in the way of abandoning their copyright? A lot of scholars say yes. You cannot just say, it's my copyright, I don't want it anymore. But what interests me is that those same scholars says that copyright is a property right. But one of the key features of a property is that you can dispose of your property. You can say, I don't want my watch anymore. I put it in the garbage and maybe someone else will take it. I don't care, it's not my property anymore. But for copyright, you cannot do that, so it puzzles me somewhat. Okay, this was the tour of the public domain. I will just say a few words of other factors that make it very relative. What I tried to show you is that the way it is defined in copyright made that every part of public domain not really strong enough because there are a lot of rules that really make it very fragile. There are other things also that make it relative. Even if something is in the public domain, there might be some subsisting rights in it, and that will prevent its free use in all circumstances. There is the perpetual moral rights. A lot of countries in the world have a moral right that lasts forever. It's the case in France, for instance. You might remember a few years ago that some heirs of Victor Hugo suddenly claimed that they still have a moral right in Les Miserables and tried to prevent the release of a follow-up to the Les Miserables story. I think that Victor Hugo just yelled from his grave, but they lost the case, fortunately. There is another thing that is really interesting, is the domaine public payant. You have also some countries, mostly developing countries, strangely enough, that ask for a royalty to be paid when you play or commercially use a public domain work. Actually, not only developing countries, because you have a very strange case here in the UK where you have the section 301 of the CDPA that says that the play Peter Pan, each time it is performed or adapted or commercially published, will generate a royalty for the Hospital for Sick Children in London. So it's really a specific case of a copyright that doesn't want to grow up. And it's really a sort of oddity in copyright. You have other things, but I won't have time if we still want to have questions. There are some other rights that might come, technological measures of protection, trademarks to some extent, neighboring rights, or things that might get in the way of a complete free use of copyright. So you see what are the issues that I have encountered by looking into public domain in copyright. The key issues are for me the difficulty in identification, the fact that public domain is not fixed. It's something that's really fragile and moving. It has unclear boundaries, and especially it is not built in a way that makes it completely safe from enclosure and from encroachment. There are a lot of things that can happen to something that is in public domain. And so saying that public domain is great because it's free use, no, actually public domain is really a tricky thing where the free use is not guaranteed. So my agenda would be to think about make the public domain more effective. And for that, I'm following two key objectives. The first one is to make it available and sustainable. And the other one is to really make it non-exclusive and non-rival. I will say a few words about those two objectives. The first one, public domain should be made available. This is something that you hear a lot those days, because suddenly the value that we have rediscovered in the public domain has prompted a lot of lawmakers, a lot of people saying things that are in the public domain should be freely available to us, to all. But it's not because there is no copyright anymore that it will be widely available for many reasons. First, because sometimes you have a public work that is in the public domain under copyright, but who is still under a tangible property right. And the owner of the thing doesn't want to make it freely available. It might be a library, it might be a museum, it might be an individual. Think about an individual that has a very famous painting of Van Gogh, but doesn't want to show it to anybody. Okay, so maybe there will be some copies of Van Gogh circulating, but if there is no copies of that work, nobody will be able to see that Van Gogh work. There are some works lost in oblivion. Of course, when we talk about public domain, we think about things that we know, big paintings, famous works. But there are a lot of things that are just that nobody knows about, that are in libraries somewhere, that are in private collections. Things that have cultural value or informational value, historical value, but nobody knows about it. And that prompts the second question, is that actually copyright, what is great about copyright for me is that it is also an engine of availability. Because granting exclusive rights by copyright is also giving incentives to people to make their work available. Because having a copyright without marketing your work, without making them available, doesn't make any sense. So you have exclusivity, and as a creator, as a producer of work, as a publisher, you want to make your work circulate in the market, in the public sphere. And this is the trick of copyright, is that it gives you incentives to publish your works, to make them known. But what about public domain? Where is the incentive? If there is no right, there is nobody who will get any exclusivity. So why would someone bother to make it available? Who would bother actually would be the public interest. But who will defend the public interest in making public domain works available? We have seen with Europeana and other projects like that there are a lot of people, individuals or states or European Commission who wants to take that role and make the public domain available. But it costs a lot of money. And you cannot recoup your investment as in copyright because it's free for use, so you cannot make it available for a price if it is in the public domain. And actually this question of funding is really interesting. And I will give you two examples of how it is now tackled, and in a way that is, for me, a bit paradoxical. The first one is a report that has been written by three sages for the European Commission in 2011. It is called the New Renaissance, Bringing Europe's Cultural Heritage Online. Those three people have been asked, how can we make the cultural heritage that the European libraries have digital and make them available to all. And this is a very interesting report, and for once it's a short one. And it says that it asks a lot of questions for works in copyright, for orphan works, and for public domain. And they ask the questions of the funding. Okay, who will pay for that? Who will pay for putting our cultural heritage online if it is in the public domain? We can make some public-private partnerships, but then we will need to get some counterpart to the private companies who will invest in that digitization process. So the main conclusion is that what is paid by public money should remain free for all to access. So it will mean that access to public domain works should be free, but reuse of public domain works should be free for individual or for non-commercial use. But it could be against a remuneration where it is used in a commercial way. That also puzzles me. Public domain should be free in all circumstances. You can reproduce it, you can communicate it to the public. You don't have to pay a price for it, even if it's for commercial purposes. So it's a new way of looking at the public domain works. There is another thing that is interesting, is that the Public Sector Information Directive, not direction, will be revised. And there is a draft now circulating about the Public Sector Directive, and they decided to include cultural heritage institutions, so libraries, museums, and to make that covered by this directive. And the key rule of that directive, because outside of copyright you might not know about it, is the way that as soon as you have information produced by public sector, commercial entities can get a right to get access to it and reuse it against a fee sometimes, but a nominal fee. And in that case, it would mean that works that are in the public domain and are hosted by these museum libraries will be governed by such a principle. So it will mean that commercial reuse of it will be subject to a fee. And for that case, there are also new rules about remuneration that can be paid. So in both cases, suddenly, the complete freedom that public domain used to know is limited to non-commercial reuse. So it's a completely new direction that the public domain is taking, and I think it's interesting. The last point, that will just leave me sometimes for questions, is the non-exclusivity and non-rivalry. You know that copyright gives some exclusivity and some rivalry where there was none before. And actually, public domain will be composed of works that are non-exclusive. Everybody will be able to use it, and non-rival. And I think those are the key features of public domain. Usually, economists or intellectual property scholars says that those are features that should be avoided. They are not good, and this is why copyright and IP are there. It's just to get rid of those non-exclusivity and non-rivalry. But actually, those are key features, and they are interesting features and some valuable ones. And I think that what would be important in setting a regime for public domain would be to find a way to make those values effective and work. It would mean that public domain should be protected against any recaptures, any encroachment. And there should be ways of ensuring an effective collective use without discrimination. We can rely on the notions of the commons, or choses communes, that we know in French civil law, that says that choses communes or commons are things that are owned by nobody, but more importantly, that are open for everybody to use. So this should be a way to make that happen for public domain. I will give you just one example. This is a picture of a famous square in a French city, Lyon. It's the Place des Terreaux, and it's an old place surrounded by historic buildings. And a few years back, the city of Lyon has asked two contemporary artists, to renovate the square. And actually, they just put, it's not very, you can see it there, but they've put some squares with lines, some fountains. And this is considered as a work of authorship, eligible for copyright protection. And those artists are very knowledgeable about their copyright. And they sued producers of postcards that reproduced the square. And of course, you cannot reproduce the square, the Place des Terreaux, to show the historic buildings without reproducing the pavement. And so those artists said, but there is a reproduction of the works protected by copyright. The pavement is protected by copyright. And in the first decision, a court said, and it was very bold, I think, from them, they said, but if we agree to give copyright to those artists, or at least to make them enforce their copyright in that way, it would prevent public domain from being effective. There is a public domain in those historical buildings, and so we will limit the enforcement of copyright of those two artists. We won't annul the copyright. The copyright is there, but we won't enforce it because it touched upon the public domain works that are in that square. Unfortunately, it was reversed in appeal, but for another ground. The artist still didn't win the case, but for a completely other reason. And I think it was a pity, because it was really interesting to say, contrary to what the Supreme Court has just said in the US, to say we should do something to prevent copyright enforcement that would be against public domain. So I would be more for going into that direction, the direction that the US Supreme Court just took in the Golem case. And just for your information, if you want to see the value of public domain works, here are some works that have fallen in the public domain in the UK this year. So you have Joyce and Virginia Woolf. You have Baden-Powell. If you are really into scouting, you can read now the book and put them online. They are for free. You have Arsène Lupin, the philosopher Bergson. You have this John Lavery painter who is of Irish origin, but who was part of the Glasgow school. So this is why I put it here, because it's a local. This is my local. It's a Belgian sculpture. So you have a lot of things that fall in the public domain each year. And for me, it's not a fall. It may be more an entrance. And I would like that public domain entrance would be something that is celebrated and not something that is considered as useless trash. Thank you.
Okay, so we have to